let us understand the authority. We have done the background of authority of partners. Now let us try to understand the whole of it. And as I said, authority is generally of two types, express and implied. Yet we can see a third type also here. But this is only in emergency cases, only in only with regards to acts in emergency. Normally, the partners do not have this authority. Only when there's some emergency, when some catastrophe takes place, when some a big loss or some negativity has to happen, only in those cases the partner has this authority. Okay, so we already know that express authority is authority which is agreed by the partners orally, or they have penned it down in the partnership deed. So that is the express. So the partners amongst themselves may agree on various authorities that the partners have, that they have, and they may want to pen it down. So it depends on them what all authorities they want to give the partners, and what all authorities they may want to take away from the partners. They may also write that a particular partner does not have a particular authority. That is, let's say XYZ are the partners in the firm, and the partners may agree that X will not be allowed to sell the goods. He can only purchase the goods, whereas Y will not be allowed to purchase the goods, he can only sell the goods. So now X has been given the authority to sell the goods. However, one authority has been taken away from him, that is to purchase the goods. At the same time, Y has been given the authority to purchase the goods and he cannot sell the goods. So, you see, partners amongst them can agree on anything, can give authority to partners on anything, because they are the owners. They are the owners. So, it depends on them as to what all authorities they want to give and what all authorities they want to restrict. So this is about express authority. We've also done implied authority. Implied authority also enables the partners to bind the firm. However, since there is no agreement or partnership deed, there's nothing specified in the partnership deed with regards to this, there are some restrictions which may be imposed by partners. Partners may not expressly give the authority, but they may expressly restrict the implied authority. See, implied authority is authority which is not express. That means there's no agreement, there's nothing written down in the partnership deed. However, this authority, which is understood from the conduct of the partners, may be restricted by the partnership deed, by an agreement. Okay, so partners may restrict it by an agreement. At the same time, this act, the Partnership Act 1932, also restricts partners from certain implied authorities. Now, what are those cases where the partner does not have the implied authority, where the implied authority is restricted? Are first, submit a dispute for arbitration. Now, what is arbitration? Now, what happens is, normally whenever we have disputes, we go to the court for the solution, for the judgment. Now, many a times, both the parties, with the agreement of the court, with the permission of the court, may agree for an settlement outside court. We call it out of court settlement. Okay, so the case which was before the court now goes out of the court, and then it is with the arbitrator. Arbitrator is a person who sits between both the parties and lets them amicably solve the dispute. He helps them to get to a solution. Okay, so court will always want that. Court is always, it will always encourage such out of court settlement because this saves the time of the court. So whenever you want to solve your dispute out of court, you'll readily get the permission. And when this dispute comes to the arbitrator, whatever decision the arbitrator makes, that becomes final. But as I said, court will be readily, it will grant you permission readily. It will be very happy to grant you permission for arbitration. But does the partner have employed authority to submit a dispute for arbitration? If a case is already sub judice, that is, the firm has already filed a case, can he refer the case to the arbitrator? No, he cannot. He does not have the right to refer a case to arbitrator. The case which is already under process, he cannot withdraw the case and refer it to arbitration or an arbitrator. He does not have this authority. Second, open a bank account on behalf of the firm in his personal name. He cannot open a bank account for the firm in his name. I mean, that becomes his personal account. If he wants to open a bank account for the firm, it has to be in the firm's name. It cannot be in his personal name. Such an authority cannot be given to a partner, and this act says this act restricts this authority. If you want to open a bank account in the firm's name, make sure it is in the firm's name only. It cannot be in the personal name of the partner. Third, compromise or relinquish a claim against the third party. Now, what do you mean by compromise or relinquish? Compromise means, to give away, to waive off. Relinquish means to surrender, to give up. So he cannot give up a right of the firm for which the firm is fighting against the third party. It is possible that a party is not paying the firm, let's say, 1 lakh rupees. So the firm has gone to the court to claim that 1 lakh rupees. Now he cannot, in the court, he cannot say, okay, it's okay with me if the party does not pay. I am ready to relinquish my right. No, he cannot say that. He does not have the authority to make such a decision on behalf of the firm. He cannot give up any right of the firm. He cannot relinquish or compromise on any claim or right of the firm. Okay. Fourth, withdraw a suit filed by the firm. If his firm has filed a suit, he cannot withdraw it. The consent of all the partners is required for withdrawing the suit. A suit cannot be withdrawn by one partner. Okay. Fifth, admit liability in a suit against the firm. Now, earlier we read that he cannot relinquish the right of the firm. Now we are studying that he cannot admit a liability. So now both ways he does not have the authority. He cannot give up a right. At the same time, he cannot accept a liability on behalf of the firm. He cannot say, okay, I accept this liability on behalf of the firm. No. He cannot admit any liability. Even if he does, he'll personally be liable. The firm will not be liable. Okay? Because he does not have the implied authority in this regard. Next, acquire immovable property on behalf of the firm. Now, to acquire the immovable property, consent of all partners is required because this is a very big decision. So one partner by himself cannot acquire the property on behalf of the firm. So now, if he cannot acquire the property on behalf of the firm, it is logical to understand that he cannot transfer or sell the property also. So he cannot acquire the property on behalf of the firm. He cannot sell or transfer the property of the firm on behalf of the firm. Okay. Last, enter into partnership on behalf of the firm. He cannot enter into any partnership with other firm on behalf of the firm, because the consent of all partners would be required here. So he by himself, he can become a partner in the other firm, but he cannot enter into a partnership with other firm on behalf of the firm. No, this can't be done. If he wants, he may personally get admitted as a partner with the consent of the existing partners. But he cannot enter into partnership of his firm with another firm. No. At first place, two firms cannot enter into partnerships. We've already studied that. But here, what we are studying is, he cannot bind the firm. Even if he enters into a partnership with other firm on behalf of the firm, then he'll be solely liable. He'll be personally liable for the acts, for the liabilities. So in all these cases, if he does anything of that sort, the firm can always say, no, he did not have the implied authority to do so. So now he will be personally liable. The firm will not be liable. Okay. So now let's study what are the acts which are done in emergency. Does a partner have this authority to do any acts in case of emergency? Yes, he has the authority to do acts in case of emergency. The important thing is, such acts should be in the benefit of the firm. They should be to save the firm from loss. They should be to save the firm from any physical or monetary loss, monetary damage. So if it is in the interest of the firm, such an act will bind the firm. A partner has the authority to do acts in emergency. Now these are the acts which are over and above the implied authority. Now partners cannot foresee any catastrophes. Partners cannot foresee any emergency, so they do not pen it down. They do not list it down in the partnership deed. They do not agree. They do not make an agreement of such acts, because these are contingent acts. They are done only in case of emergency, and you never know when the emergency arises and what type of emergency arises. So there cannot be express agreements with regards to emergency acts. At the same time, implied authority is for normal course of business, but emergencies are not, they do not fall into the normal course of business. So these acts are over and above the implied authorities, because implied authority a partner has for normal course of business only, but in case of emergency he may go out of the way and do something to protect the firm from losses. So this is over and above the implied authority. Okay, the important thing is, it should be done for the benefit of the firm and in good faith. Let's move ahead.